Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, now it is my honor and privilege to introduce our speakers this afternoon. First up, we have Steve Block. Steve is a highly experienced mediator, arbitrator, special master, and referee. Since 2003, he has handled hundreds of disputes as a neutral, spanning the full spectrum of civil litigation, including business, partition matters, employment law, family law, products liability, personal injury, medical malpractice, real estate, partnership disputes, premises liability, and uninsured motorist claims. Prior to joining ADR Services, Inc., Steve spent 43 years as a trial lawyer and civil litigator. Through his extensive trial and dispute resolution experience, Steve has developed a broad working knowledge of the complex issues that often present in ADR proceedings. He draws upon his intimate understanding of the challenges, risks, and benefits associated with trial in order to present the parties at mediation with realistic and cost-effective alternatives. His down-to-earth demeanor and legal acumen have earned him the respect of counsel and clients alike, leading to the resolution of numerous disputes. We also have with us today Ralph Lombardi. Ralph joined ADR Services, Inc. after a 46-year-long trial career, handling a wide range of civil matters with particular emphasis in the fields of medical and legal malpractice, products liability, insurance coverage and bad faith, and personal and catastrophic injury. In addition to evaluating and settling otherwise disposing of hundreds of cases prior to trial, he tried to verdict or judgment or arbitrated to binding results over 100 cases, including medical and legal negligence, catastrophic injury, wrongful death, automobile crash worthiness, design defect, insurance coverage, and insurance bad faith claims. As a litigator, Ralph's practice involved representation of the Kaiser Foundation Health Plan, Kaiser Foundation Hospitals, and the Permanente Medical Group in medical malpractice matters, and the handling of various insurance coverage and bad faith lawsuits. In addition to founding Lombardi, Loper, and Conant, Mr. Lombardi is a standing member of the American Board of Trial Advocates and has published opinions as appellate counsel in both the California Court of Appeals and the California Supreme Court. So thank you for joining us this afternoon. I will go ahead and pull up the presentation and you can take it away.
Thanks, Katie. I'd like to welcome everybody to the Competence It's More Than Knowing the Law program. Until several years ago, this mandatory session was actually called substance abuse, and that was the entire focus of it. Many of you may have attended programs. I know that I had seen some here in the Bay Area. Very accomplished, very experienced, and very well-respected trial lawyers who had some very telling personal stories about their problems with substance abuse, how they had managed and gotten through those problems and the resources that were available and things along those lines. Now, more recently, in 2018, the feeling was that it was necessary to expand beyond simply substance abuse to other things that would potentially impact one's ability to practice law. So it was renamed Competence. And if we could go to the next slide, Katie. Under Rule 1.1b of the California Rules of Professional Conduct, in addition to learning and skill, a lawyer has to have mental, emotional, and physical ability reasonably necessary for the performance of legal services. The next slide. And today, Steve and I are going to talk about the meaning and the importance of those terms in the practice of law, including causes of incompetence, frequency with which incompetence may occur, or those causes occur, ways to self-assess your competence, your professional duties in connection with personal or colleague impaired competence, malpractice, and lawyer discipline, and resources for help when mental, emotional, or physical abilities are impaired. As Katie told you, you can submit questions through the Q&A button at the bottom of the screen, and we'll try to respond those either on the fly or at the end if we have time. So we're going to start with the rules of professional conduct. If we can go to the next slide. Steve, what do the rules have to say about competence?
Thank you, Ralph. And Katie, thank you for your nice introduction. The new rule of professional conduct 1.1, paren A, close paren, sub B, really are the sort of the intersection of what we're going to be talking about today. And I have to say that when I first heard that, I noted substance abuse wasn't, because I, with the last name of Block, I'm due January 31st of this year. I just noticed that, well, what happened to all the substance abuse? And as Ralph has said, it's broader now. I think it's clear and I think it's appropriate when we're talking about competence. The mandate that we practice with competence is 1.1 sub A, stating a lawyer shall not intentionally, recklessly, or with gross negligence or repeatedly fail to perform legal services with competence. It's an express mandate. The definition comes with our next slide, and that's in Rule 1.1b. So to be competent in compliance with the mandate, you must have, number one, the learning and skill necessary to perform the legal service at hand. You have to have the mental ability, the emotional ability, and the physical ability, all four of those reasonably necessary to perform the legal service. And in terms of physical ability, I don't think we're talking about a lot of the really necessary and great work that's been done to accommodate people that have certain physical disabilities and need an accommodation. It really has to do with your availability to be, alert and oriented times 4 and be able to conduct the legal service, whether it's drafting, whether you're trying a case, making a court appearance, or otherwise. Let's talk about learning and skill. If you're handling a case that is complex and it's going to be a jury trial, it's going to be tried in front of a jury, it's a complex piece of litigation, and all of the workup for that case is going to be complex and a long gauntlet that you need to travel through with experience and enough learning to understand what's going on and to competently perform that. Then you have to have that trial experience. And if you don't, and you undertake to handle the case, maybe you're going to take it for a friend, maybe you're going to take it for a relative, it might be a good business contact. But if you get involved in handling a case involving complex trial experience, you have to have the learning and experience to handle that properly. That experience is necessary to perform that legal service. A couple other quick examples. Patent law. I don't know a lot about patent law, but that'd be a good reason for me not to take a patent case. I think a lot of engineers and people that spend, all of their time performing services in patent law are actually patent lawyers. So that's another good example. And it really moves across a lot of the specialties, family law, criminal law. Everything's become so specialized, and you have to be careful about getting involved. I'm sure everybody here knows one way around that, or one way to stay in compliance. Maybe you're the person that knows the client the best. Maybe it's a catastrophic loss, and it's really important for you from an emotional standpoint in supporting the family. You can associate the lawyer or lawyers that you need so that the complex of all of your services make sure that the legal team has the necessary, reasonably necessary experience to conduct whatever services are needed in that case. Moving on to the next slide. I'm sorry. Pardon me. Ralph, what are the common causes of mental health, alcohol, and drug abuse problems as they relate to competence?
Well, Steve, what we've seen is that any single factor can cause or can impact competence. And more often than not, though, they're synergistic and one leads to another. For example, you stress, well, a drink or a drug maybe relaxes me. Or anxiety, fear, oh, a drink or a drug calms me down. Depression, I feel better when I have a drink or a drug. Financial problems, a drink or a drug helps dull the problem. Drugs or alcohol usage, of course, leads to stress and anxiety and depression, or it certainly can. So it's this synergistic effect where these things can sometimes lead you into a downward spiral, excuse me. So the issue of mental health is paramount. And the question is, why? Well, let's look at this next slide. The first 6 words of this slide are a truism. That is that the practice of law is stressful. Now, Steve's going to talk in a minute about how it causes anxiety or how often that occurs, depression, substance abuse. But let's talk about stress. In my view, the practice of law involves both recognized and unrecognized stress. At least that's what I call it. As Katie told you, I spent 46 years as a trial lawyer before joining ADR services. So there were plenty of opportunities for recognized stress, whether that was in the form of discovery issues or motions or presentation of evidence during trial or waiting for a verdict or getting a verdict, lots and lots of things. But there was also unrecognized stress. And that was that, at the conclusion of a trial or an arbitration that had been gone for a week or 2 weeks, but I would always feel better and relaxed, kind of, I thought. And I thought, well, the stress is gone. But then when I retired, I actually found that it wasn't quite the case, because all of a sudden, about a month after I finally retired, I kind of looked around and realized that I was seeing more, I was appreciating more. The sky was bluer. The flowers looked nicer. I was a little easier to get along with. I slept better. So there were a number of factors. And I think that all it tells me is that as lawyers, we carry around a mantle of stress, and we just have to learn to deal with it and manage it and not let it manage us. And I certainly do not intend to argue that stress is the exclusive venue of trial lawyers. Absolutely not. It is endemic to the profession. It's something we all see. And so let's take a look at some of the common stressors, the things that we run into. Can we have the next slide, please, Katie? So here we have a list of a number of things that we run into. Level of responsibility. Maybe it's a bet the company case. Maybe it's a criminal case where someone's freedom is at stake, or their life potentially is at stake. Maybe it's all just money. It doesn't matter. There's this level of responsibility that you always feel. Rigid deadlines, again, particularly in the litigation context. The whole situation from beginning to end is full of deadlines, whether it's time to answer the complaint, time to do discovery, time to respond to discovery, time to file motions. There's always a deadline, and you're always working against that. And of course, most people, I think, at least many, don't have the luxury of only working on one case at a time. So you have deadline on deadline on deadline in various cases. And this all contributes to stress. Competitive atmosphere. I suspect that if we were to take a poll of the audience and said, how many of you regard yourselves as competitive? Probably a very significant portion of you would say, yeah, that's me. And that simply adds to the stress as well. Financial stress and risks. Whether you're a one-person law office or a small firm, medium firm, large firm, there are various financial pressures that can be involved. If you're on the plaintiff side, you may have issues with costs. On the defense side, you have issues with other things. There's always something. You feel responsible for the employees that you have, for their families, for making sure that you keep everything on track. So finances are another issue. Feelings of inadequacy. I think it's natural that people have a tendency sometimes to think, oh, gee, I'm going to go up against the number one lawyer in the state. How can I do that? Rightfully or wrongfully, you just need to get through it. You have got to have a positive mental image. And then excessive demands of clients. I think the big thing to remember here is that whether you're talking about a CEO who does have a bet the company case or a huge transaction, or your next door neighbor who is in a fight over trees, to them, the case is the biggest thing going on in their lives. And that oftentimes gets pushed down onto you. And so those demands can be another stressor. Steve, what's your view of some of these?
Well, Ralph, I think the first thing that we should point out is that when we say you, we're including us. Our observations, of course, I think are derived from our own personal experience over the length of time that I can't believe we've been practicing. But, everybody has their stress. Everybody has disappointments, personal lives and their legal lives or whatever it might be. And so when we say you, we're talking to, all of us in this community and in this particular profession. Frankly, I look back and kind of chuckle, fortunately. I really don't know how and don't remember, a lot of the granular issues of stress and worry and fear. I know I had it, but I don't know really how I did it. When I was 40 and married, 4 kids, doing personal injury practice and the depositions we took. I mean, it was a lot. Great experience, your learning curve, it's exponential. But it's pretty clear in my earlier years that I wasn't sort of heeding the warnings, the cautionary tales that we're all kind of compelled to think about when we have the discussion we're having today. I'm thankful that, for certain risk that we're going to be talking about that I never, suffered beyond what, I think everybody has to suffer a certain extent. So anyway, generally speaking, we're all stressed. We have personal and we have professional stress. I think that, the older I've gotten and the further I've gone through my practice, when I worked for a large firm, then I had a medium firm, then I was solo, then I started to go into ADR. One thing that is really important to do is to be honest with yourself. We know when something's wrong most of the time, even if you're a drinker and you're already, headed in the wrong direction, it. Some of your colleagues or friends may know it. The most important thing I think that we can, force ourselves to do when we're trying to establish that discipline we need, our self-discipline, is to get ahead of these stressors and anxiety and depression and all those things. There are things we can control as lawyers, and there are things we cannot control. Of course, we hear that with respect to general ways to approach life. Don't worry about the stuff you can't control. But the things you control, and especially within the legal profession, we can try to get ahead of the impact of the stress and anxiety. Good example, you're a young lawyer. Things are different today than they were when I started. I mean, everybody went to lunch, and judges were in the same establishments at the lunch hour. Some of them were, having a 2-martini lunch. It's not as common today. But if you're in a position where, you're just feeling like it's not a good idea for you to spend your lunch hour, trying to be part of the firm or trying to maybe meeting a client, and that maybe it's just not a good choice for you, you need to be mindful about it and aware of it and take steps before it becomes a problem. So in short, stay ahead of the stressors that you're aware of. You first of all have to be aware of them and take an inventory. Stay ahead of them, understand the stressors you cannot control. There's going to be always a certain amount of stress, fear, feelings of inadequacy, all the things that go along with your development throughout your profession at all the various stages that you'll go through that obviously many of the audience here has gone through. We can't do much about most of them, but there are other parts or other stressors that come up that we can. I'll just give you a couple of examples and then we'll move on. For example, if you've got a small practice and the person that does the client selection, you have to really, maybe there's probably continuing education courses on it. Client selection is really important. And I look back, I'm thinking, I got pretty good at it about maybe 10 or 12 years out. And I learned because I picked the wrong or, accepted certain projects before that were just, nightmares. I'm talking about stress. I had no business either because of the client's attitude and some of the early signals in the interview or just the nature of the case. Another area is simple, basic fundamental things. Put your personal plans on your calendar early. Make sure the people at the firm or your partner, whoever it is that needs to know, let them know early. And then stick with it, because later on we're going to be talking about well-being. And if you've got a vacation planned with your significant other or with a good friend and you put down payments down, and at the last minute you have to say, you know what, I don't know what I'm going to do. They've ordered me to fly to Portland to take a week of depositions. So don't procrastinate. Think ahead. It's your well-being at the outset that's the most important. And we'll talk about that and our overall health later. I guess the other thing that comes up when we're talking about all the rigors of the practice is thorough preparation. I mean, the best lawyers that I had the blessing really of practicing against or among, I observed in trials and in preparation for trial, they were prepared to the nth. They knew the case better than the clients knew the case. And that relieves stress. If you're going to trial or let's just say you have a meeting with the bet the company type of case that Ralph's referring to, and you haven't read the LLC or the operating agreement, and you haven't talked to the tax counselors before the meeting, that's uncompleted work that's going to raise your stress going into that meeting. Preparation is the key. And then finally, one of the top complaints with the state bar is that lawyers won't get back to them, returning phone calls. And, I'll confess right here, there have been times where I had a stack of back then yellow or pink messages, look at them going, oh God, I don't want to talk to this guy right now. And I'd set it aside. I'll do that later. And what happens is it becomes a source, just a big ball of pink messages that cause untold stress, feeling guilty about not getting back to them, and then when you call them and say, hey, I haven't finished the agreement I was going to send to you. I just wanted to get back to you right away. Most people are like, oh, great. Well, hey, thank you so much for advising me. So you got to keep track of your interaction with clients, deadlines, et cetera, and it will help lower the stress. Ralph?
Yeah. Well, Steve, we've certainly talked about stressors and stress in general in the practice of law, but how often does that lead to mental health problems and or drug, alcohol abuse type problems? Maybe we go to the next slide, Katie.
Well, just a confession, I think Ralph shares some thoughts, but I wasn't shocked, I suppose, but I will say that the statistics and the interpretation of all the statistics and all of the articles and professional journals that have been written about substance and alcohol abuse in the legal profession is just really, really, it's kind of scary in a way when we look at the overall health of us all and our colleagues and the impact it has on our profession. I think one of the well springs of this new perspective and understanding that we all share now was born out of the Hazel and Betty Ford funded research project by the ABA Commission on Lawyer Assistance Programs. It was in conjunction with other participants like the National Judicial College and other collaborators. They published the results of that in February 2016. If you Google any of those keywords, you'll have 15,000 hits. But just to kind of look at at the time of publishing, the attorney and clinician Patrick Krill, Krill, who was the architect of the project and how they were going to go about doing it, he stated, "This long overdue study clearly validates the widely held but empirically undersupported view that our profession faces truly significant challenges related to attorney well-being. Any way you look at it, this data is very alarming and paints a picture of an unsustainable professional culture that's harming too many people. Attorney impairment poses risks to the struggling individuals themselves and to our communities, government, economy, and society." I'd add, and clients. "The stakes are too high for inaction." So we're going to take a look at the statistics. Next slide. Which I think, presents a cautionary tale for all of us, for the well-being of our profession and really for the well-being of our personal lives too, as lawyers. Let's take a look at mental health. 14% of the general population in the United States will suffer from mental health problems, such as depression during their lives. 14%. 33% of lawyers will suffer mental health problems like depression and anxiety and feelings of inadequacy. Lawyers are 3.6 times more than the general population to suffer from depression. And disturbing, of course, the topic of suicide, it's something that doesn't spare anybody in terms of knowing people, family, relatives, people you might know in your profession. In the general population, deaths by suicide is approximately 14 per 100,000 deaths as of 2019. The national average rate for lawyers' suicide is 66 compared to 14, 66 suicides per 100,000 deaths. Lawyers now have a higher suicide rate than dentists, who used to hold the top position. Now let's take a look at alcohol and drug abuse. 20 million Americans are estimated to be addicted to alcohol or drugs. 18 to 20% of lawyers experience drug problems at some point in their career. And as you can see from the slide, 32% of lawyers aged 30 and under are problem drinkers. 28% of lawyers with 10 years of experience or less have the highest rate of alcohol problems. 25% of men and 15.5% of women had problems with substance abuse from the Hazelden Betty Ford study. I am aware of commentators that have said that that's starting to flip. I don't have the current statistics on it. The suggestion that both men and women are getting close to being at equal risk of developing problems with substance abuse, according to all these statistics that have been crunched and analyzed. And then, of course, it's not directly on point, but we really can't not mention deaths from the overdose of opioids, primarily fentanyl. From March 2020 to the end of April 2021, there were 306,000 deaths from all opioids, 673,000 of which were fentanyl. So the combination of fentanyl and other likely mostly prescribed opioids, like OxyContin, Vicodin, and all the other opioids, prescription drugs, led to approximately 100,000 overdoses. The percentage of that 100,000 that are lawyers I haven't seen a tally on that yet, but it'll be interesting to see where we fit in on that part of the analysis. Ralph, just stepping back for a minute, we've talked about mental health and emotional health. We've talked about learning and skill. When it comes to physical health, if you're in great physical health, is that enough? Does that really give you kind of an upper hand to enjoy a career without the risk of becoming wholly or partially incompetent?
Well, if we can go to that that next slide, Katie.
Yes, 12.
And the answer is no, that it doesn't, Steve. It's certainly a good start. being healthy is very important. We know that poor physical health can lead to stress, further more stress, and just a debilitating downward spiral that impacts confidence. But it's not necessarily, the converse is not necessarily true. So the fact that you may be in the greatest shape around, a marathoner, all those sorts of things, doesn't mean that the whole picture is intact. You know, there's a recent example that many people may be aware of, at least if you're football fans. There was a game recently, an NFL player stripped off his shoulder pads and jersey and left the field during the middle of a game. At least outwardly, I mean, you looked at this fella and he looked like, boy, great shape. And you wondered, wow, this guy's in good shape. Well, in the post-game interviews, though, with the coaches and the teammates over the next few days, there were various references made to, quote, personal issues or personal problems. And whatever those personal problems or personal issues may have been, they clearly impacted his competence as a player. And in fact, they were more important than his physical condition. And I think when it comes to competence as an attorney, the studies have shown that, in fact, the most revealing factor is in the state of one's well-being. So we go to the next slide, Katie. And Steve, what is well-being? You know, how do you assess it?
Yeah, I think in the recent past, we've heard a lot about work-life balance, which was, gee, you know, you can't work too much because you have to play, and you can't play too much because you have a responsibility, you got to work. And I think they're on the right track, or we all, I suppose, as a society, we're on the right track. But the study that came out, the Hazel and Betty Ford study, really took a nice slice into the concept of well-being, which of course we all heard of. At first blush, it seems kind of elusive and vague, but I think it's important to talk about briefly because it's really an effective tool to assess or survey the status of your personal and professional life. It's a tool, perhaps as a hedge against the risk of drug and alcohol abuse through your mindfulness of what in your individual circumstances, what you consider your well-being to be, what you might aspire to, you know, as you move your way through the professional life. It's been defined in different ways. One common thought is that the state of well-being, it's when you're comfortable, healthy, and happy. But because things can and do change from day to day and from year to year, or in a New York minute, it's understood that well-being over time will include and needs to include in the big picture. Are we feeling satisfied with our lives as a whole? So, you know, I mean, I don't know what I thought back when I was 25, you know, yeah, everything seems to be going okay. But it wasn't a very deep analysis because my life was different then. Another thing is to survey your feelings of, you know, do you have a sense of purpose? Well-being kind of depends on that. And we know that people, all of us, want to feel that we have a sense of purpose, that we're relevant, that the people either at work or the people we love or family and friends, we want to be felt to be, we want them to feel valuable. That we care about them and they care about us, and that we, you know, as a humans, one-to-one and group to group, that we're relevant and we're valuable. Another question you hear, and, you know, I don't know, I think it says a lot. It came out of a movie from somewhere, but, you know, do you have a happy place? You know, another way, or do you have a refuge? And I remember joking with my spouse years ago when I'd be coming back from a day of depositions against somebody like Ralph at the UCSF Medical Center. You know, I'd come into the house and I just go, oh my God, this is such a refuge. Little did I know, but it was an early indication. I mean, it's a good sign that maybe in the long run, through all of the angst and the ups and downs and stress and worry, just the, you know, being able to mindfully understand that, boy, I'm home, it's a refuge. I've got stories that, you know, we all have stories that suggest that even if you're in your refuge, it doesn't mean you aren't preoccupied and totally stressed out about work. Another question you might ask yourselves is, what brings you satisfaction, meaningful, and happiness? I'm going to jump down here a little bit. I don't want to take too much time, but we all have, and the question to ourselves is, do I have activities that bring me a sense of well-being, like enjoying spectator sports, the arts, reading? It could be music, either playing it or listening to it, taking walks, hiking, involvement in a charity, community activities, kids activities, traveling with friends, going to wineries. Even can be something that, kind of makes the hard work week special if you're going to decide to go wine tasting. And if we look at the practice of law, I'd suggest that some of the fundamental questions as you're doing this personal survey to see about your mindfulness: do you enjoy your colleagues? Do you enjoy the subject matter of your cases? Are you respected? Do you think you're respected or feel respected and treated fairly in the firm? If you're an owner, do you enjoy supervising employees, or do you consider it just the worst thing you have to do in your day? Do you respect the reputation of your firm and you don't feel bad being associated with it? And do you feel like your colleagues have your back? If you answer no to any of these questions, you may want to address them on the topic of well-being to, on an ongoing basis, take a survey of, how you look at how your life's going.
Steve, it seems to me that there are a plethora of various things you might look at to try to assess your well-being. But I wonder if maybe kind of a short, quick one would be, when you wake up in the morning, are you happy going to work? Do you like going to work? Or is it just a complete drag? We all have ups and downs, and there were certainly some days I had no interest in going to work because I knew I was going to have to do a particular thing or deal with a particular person I didn't want to have to deal with. But that certainly was not the case normally. So I think that that's really something you might think about just generically as you do this sort of well-being self-assessment. How do you feel about going to work?
Yeah, that's a great question. Yeah, I can remember driving to a deposition, and at least in my mind, going, no, and then you get there, take a big breath, straighten yourself up and go in and good morning. But I think that's a little silly, I know, but I do think that's a really good place to start.
Well, why don't we, at this point, let's move on to the next slide. And let me ask you, are there other signs or symptoms of a lack of well-being and of mental health or drug or alcohol abuse that we can talk about?
Yeah, this little preview. This is going to go into what are our obligations to to the bar for our own problems, and do we have an obligation to consider colleagues that might be having some problems? So, how do you know if you or a colleague is having a problem? And of course, most of us are familiar. I'm sure everybody here is familiar with the basic signs of alcohol and substance abuse. There's some nuances that I don't think are important here, but generally speaking, odor of alcohol, people that are kind of slow or staggering, their eyes are glazed over, maybe they can't remember things, they're sweaty, tremors, they're shaking. Maybe they come in and it looks like they have like no appreciation for the fact that they aren't, their personal hygiene appears to be, there's a deficit there, even beyond maybe the way they show up every day. But when the objective signs like these are not apparent, changes in behavioral patterns in yourself and others can evidence ongoing mental, emotional, and physical problems, often, not always, but often resulting from substance abuse. And again, there's a checklist. You can get hundreds and hundreds of indicators that may relate to this question. But generally speaking, marked changes in personality and behavior. So somebody that yourself, maybe you always love to go to work, and then you notice it over a 2 or 3 or 2 month period of time, you just don't have the motivation. You're irritable, you're agitated, you're having angry issues with your friends and family and people at work. There's changes that are again kind of striking if you think about it in your daily routines. If you're sitting there like I have, I confess during several occasions over my 43 years where I've got a stack of pink messages, and I'm thinking to myself in that little right brain conversation with myself, God, why didn't I call these people back? Now I've got a problem. I haven't called this client, for 10 days. I've had her message for 10 days. What am I going to say now? Now, I had some strategies for that. First thing I do is apologize profusely. I'd never tell her. She goes, I know you're busy. I always say to people, I'm not too busy. I have an obligation to return the call promptly. That would often solve the problem because, it's self-effacing and it's honest and people go, okay, great, no problem. What are we doing? How's the case going? Anyway, that's phone calls. They cause a lot of stress. They're little sleeper stressors, being habitually unprepared, late for court, you're procrastinating in preparing documents, so you're relying on legal assistance and other people to prepare. You've got a statement of facts or disputed facts on a motion for summary judgment. You give it to your legal assistant at 2:00, on a Friday and say, hey, this has to be filed today. It's your problem. And so not only have you been stressed waiting up to the deadline, but it might not be something that you're used to. Maybe you always, you didn't procrastinate. You gave yourself enough time. You didn't want to put your staff in a horrible position because it makes you feel bad. You don't want to do that to them. But now all of a sudden you find yourself doing that. That's kind of a wake-up call. What's going on here, Steve? Should have had that. You should have come in on last Sunday. You'd be less stressed and you wouldn't be trashing your loyal people that assist you in carrying out this, this task. Repeated problems with opposing lawyers beyond the norm. Maybe you get along with everybody mostly, and all of a sudden you're having problems with everybody in depositions, in court, or otherwise. Drinking while driving is always a big one. Losing interest in once enjoyed activities and just kind of feeling isolated. So I think we can move on from that. Those are some of the signs in both ourselves and perhaps in others that are some of the cardinal signs and symptoms of something's going on, a mental, emotional disturbance, or and possibly due to substance abuse.
All right. Well, Katie, if we go to the next slide, then, Katie.
Yes.
And so if you observe either in yourself or in others around you, signs of potential competence issues, whether it's mental health issue, a drug issue, an alcohol issue, whatever it might be, the question arises, well, what duties do you have as a lawyer yourself, or what duty do you owe to your colleagues or to the bar in connection with your colleagues? And I think that the thing to keep in mind is that a lack of competence that's caused either by physical, mental, or substance abuse issues, it's not just a personal problem. It can create a disciplinary exposure. Under the rules of professional conduct, an individual attorney may have a duty to withdraw from representation. Some circumstances, a colleague of one who's incompetent has to be required or is required to take action. Can we go to the next slide, Katie? If we look here, first, just at the responsibilities of you as an individual lawyer, Rule of Professional Conduct 1.16 deals with terminating representation. And here 1.16A3 requires withdrawal if a lawyer's mental or physical condition makes it, quote, unreasonably difficult to carry out the representation. I have not found any cases dealing with the rule or its predecessor, but other cases make clear that an impaired physical or mental condition is not a defense to a charge of incompetence. So presumably a failure to withdraw when required could constitute a whole separate ground for discipline. The interesting thing, too, is to contrast the rules that you see up there, contrast the first one with 1.16B8. An attorney may withdraw if a mental or physical condition renders it difficult to carry out the representation effectively. How you draw the line between difficult and unreasonably difficult, for me, is pretty tough. I think that's a very blurry line. But what's clear is that the mental or physical issues which might render a lawyer incompetent have both personal and professional ramifications. So let's go to the next slide if we can, Katie. Steve, we talked about the duty of an individual lawyer who becomes incompetent to withdraw potentially. What are the duties, if any, of those around that lawyer?
Well, that's a good question, Ralph. And generally, there's no duty to drop a dime or contact the state bar to raise the issue of a colleague that you believe is showing these either physical signs, behavioral signs, or both of some sort of problem that's causing what you believe is incompetence. Let's go to the next slide. The exception to that general rule is that there are three categories of sort of functional positions within a firm or within a large firm or a small firm, but when you have colleagues that you're concerned about, that do require you to take steps. The first one is if you have managerial authority. Let's say you're the I don't know what they call them these days in the large firms, but the responsible managing partner. And somebody and perhaps one or two or three or a committee of lateral people that have managerial authority within the firm. They must make reasonable efforts to ensure that the firm has measures giving reasonable assurance that all lawyers in the firm comply with the rules and the State Bar Act. And I'll leave it up to those that draft procedures and protocols and employee manuals. There's all kinds of opportunities in a firm of that size, and if you have somebody that is in the managerial authority position, to do continuing education within the firm, to draft those types of documents, to make sure that all the lawyers know that it's not appropriate, it's not accepted here, and that we're here to help. The second category that can require you to take action is if you're a direct supervisorial, if you have direct supervisorial authority over the lawyer you're concerned about. So if you're the head of trial team A that does all court trials on partnership dissolution and corporate things like that, and you're the managing, the direct supervisor of that unit, and there's a lawyer within that unit that is having a problem, again, you must make reasonable efforts to comply with the rules and the State Bar Act 5.1b. And that, that's obviously structurally related to sort of the procedures and protocols and rules set by the managerial authority. Finally, if you're a supervisor, let's say within trial team A, you aren't the head of it, but you're a senior associate or a junior partner, and it's known that you have direct supervisorial authority over some newbies, 2-year lawyers or 1-year lawyers or 4-year lawyers. If you directly supervise another attorney and you have knowledge of conduct at a time when consequences can be avoided or mitigated, you must take reasonable remedial action. Next slide. Ralph, we've talked about competence as it relates to, the quality, ultimately, of the sufficiency of the legal service that you're rendering, both from the bar's importance and for the client's importance, for sure. Is there a difference between legal malpractice and competence, or are they the same?
Well, they're not the same. There can certainly be an overlap, but there is a difference, basically, and that is that Rule 1.1 of the Rules of Professional Conduct requires intentional, reckless, grossly negligent, or repeated incompetent conduct in order to warrant discipline. And that's consistent with the longstanding Supreme Court authority in California that a single act of ordinary negligence should not subject a lawyer to discipline. There's some language in a case that came out a number of years ago called Lewis against the State Bar, a 1981 decision from the Supreme Court that was referred to earlier ones, 28 Cal 3rd, 683 at 689. And the court said, this court has long recognized the problems inherent in using disciplinary proceedings to punish attorneys for negligence, mistakes in judgment, or lack of experience or legal knowledge. So if that's all you're dealing with, then no, it does not mean that a lawyer who has done one of those things has necessarily violated the competence rule. A missed statute of limitations, for example, due to a calendaring error, is not going to suddenly give rise to a disciplinary action for incompetence. Now, on the other hand, a missed statute because of the lawyer's repeated intoxication and failure to properly, maintain a calendar might well give rise to not only a malpractice claim, but also potential discipline. Can we go to the next slide, please, Katie? Now, the question then becomes, well, if there are disciplinary charges filed against an attorney based on alleged incompetence, are those personal issues a defense? And the answer is no, they simply are not. And the Supreme Court has held that the primary purpose of the bar disciplinary program is to protect the public, so that the court, here, I'll give you another small quote. However, even in the face of serious personal problems, an attorney has a professional responsibility to fulfill his duties to his clients or to make appropriate arrangements to protect his client's interests.
Hey, Ralph, with that language and that ruling in mind, let's just take a quick look at a hypothetical where an impaired lawyer with compliant learning and skill and no prior violation of the rules of professional conduct, and as a direct result of a recent catastrophic loss, like the death of a spouse or a child, that leads to excessive drinking and prescription drug abuse, over time to the point where he or she becomes incompetent. Will the state bar at least consider that story and even potentially give him or her a break, perhaps a censure or an agreement to seek help? Or do you see that as, how do you see that with respect to the Smith case you just talked about?
Well, I think if I go on a little bit further in Smith, that same quote says, while this court may be sympathetic to petitioner's personal difficulties, the primary concern must be the fulfillment of proper professional standards. So we're back to, I guess, number one, is there going to be discipline? Yes. Number two, can the personal circumstances result in mitigating that? I think so. I mean, I will be the first to admit I do not practice in the state bar court. Fortunately, I've not been involved in disciplinary matters, but certainly as I read it, that, yeah, it'll be considered, but it's an explanation, not an excuse.
So just in mitigation, perhaps.
Yes, that's exactly right. So, Steve, I think it's clear that whether it's physical, it's mental, it's substance abuse, any of those issues, or in combination, they can cause both personal and professional difficulties. So the question is, all right, we know all these things can create problems. So how do practitioners determine if they need help, and if they do, where they get it?
The first thing, I think.
Slide, Katie.
Yeah. Are you in slide 21? 22, 20, 21. Okay, well, I think the first thing we need to recognize is asking for help can really be a problem. It's not, I think a lot of people are wired to the point where they don't want to ask for help. It's their business. They don't want anybody else to get involved. They want to handle it themselves. And that's usually a failed strategy. I mean, the magnitude and the risk of the problems that come out of these problems we're talking about today with mental health issues and substance abuse, they are, the combination of them can corrode and erode your entire life, not the least of which is your practice of law. So I don't think it's an overstatement to say that the notion of taking a step and asking someone or telling someone that you trust, that you respect, that it's courageous to do that. It's courageous because you recognize you've got a problem, you're at least showing some effort to try to deal with it, and you're doing it to protect all of those people around you that you don't want to hurt. Again, family, friends, your colleagues, your reputation, all of that. So we all recognize it's hard to ask for help, but you just have to do it. And the important thing is the timing of asking for help can be the fork in the road between going left perhaps and getting help, maybe going on a little sabbatical. Your clients now maybe are absorbed by other people in the firm, but all before you're by definition incompetent. And you have time to correct the problem before you do permanent damage to your clients, the firm, and your reputation, and may be disbarred. So the earlier, the better. And it goes back to try to anticipate these stressors, anticipate how they're affecting you in your personal and your professional life. And if you don't, they're going to dog you to one extent or another throughout the future until they're taken care of. And again, this isn't a lecture down to our audience today. This is I could just as easily be talking to myself. All of us have stuff that is over there in the parking lot, perhaps, things that we need to get on to take care of. It could be anything. But in this case, it's the risks are so dramatic and damaging. They can't sit in the parking lot for a while. You got to bring them out. A good start to finding out, just kind of a private exercise that's available. It's interesting. It doesn't take a lot of time. Is to look at the next slide. Look at the 20 questions from the State Bar Lawyers Assistance Program that you answer yes or no. And before I just go through a couple of the examples, I'm not going to read all of them. It says at the end in terms of scoring, and there's no curve here. They're going to score on the curve. It's just yes or no, and that's it. If you answered yes to any one of these questions, it's a definite warning you may have a problem with alcohol and or drugs. If you answer yes to any two of these questions, the chances are that you have a problem with alcohol or drugs. And if you answer yes to three or more, you definitely have a problem with alcohol and or drugs. So looking at these questions, just as some samples, do you lose time from work due to drinking or using? Is drinking and using making your home life unhappy? Do you have any information that drinking and using might be affecting your reputation in the legal community? Have you had financial difficulties that you know are a result of drinking and using? You think your ambition is decreased?
Steve, let me interrupt just for a second. We're getting real short on time, so we want to move just to the next one.
That's fine. Thank you. I thank you for that.
Mm-hmm.
Okay, so the Lawyer Assistance Program is up on the slide. You can find it very easily by accessing the State Bar website. Other resources would include the legal resources, the other bar, Judicial Officers Assistant Program. There's hundreds of professional organizations with inpatient, outpatient, and virtual therapists and addiction physicians and counselors. Al-Anon, Betty Ford, these are all sources where you can make a phone call. The only other thing I would say, don't forget about the importance of having mentors, whether it's a senior lawyer or a colleague, people you trust, they'll listen to you, they'll make recommendations, they may give you some really good guidance, they may have handled something like this before. And that's about it. Ralph, do you have any closing comments to wrap this up?
Well, I think what I would say is this. You've talked about the Hazelton Betty Ford study that was done a few years ago. That's the National Task Force on Lawyer Wellbeing. And what they said in their report in 2017 was, quote, to be a good lawyer, one has to be a healthy lawyer. Sadly, our profession is falling short when it comes to well-being. So I think our hope here is that this program will provide some small push toward eliminating that shortfall, and hopefully has been a benefit to folks. So thank you all for coming and letting us chat with you this afternoon.
Thank you very much.